I'm preparing for another foreclosure trial, and I'm going to address a subject that comes up quite frequently now in the context of foreclosure trials, and that is the requirement that the bank, as a condition of getting a judgment of foreclosure, tender or surrender to the court the original promissory note and the context of that foreclosure trial. Now, some courts are going one direction and saying that it's not required for a plaintiff to come into court with that original blue ink note and give it to the court as part of that trial. While other courts are following the rules and requiring that that plaintiff actually tender the original promissory note in the context of the foreclosure trial. Now, I got to tell you, at least in the second district of Florida, the law seems very clear, and I'm going to link to that particular case right here. It's called Fair versus Kaufman, and that makes it clear that it's a requirement of foreclosure at the trial when properly objected to, and that's an important point, that the plaintiff submit the original promissory note. Now, again, that proviso there is that the defense attorney has to make a proper objection to the introduction of a copy or other note at trial. And that's part of the problem is I don't want to judge folding over the rules for defense or anybody. And so if the defendant isn't there making a proper evidentiary objection and using the case law in that circuit, then they may not need to produce a promissory note. And another little asterisk here, a footnote to this argument is there is some countervailing argument from different appellate jurisdictions that may not apply. So you got to understand the technical requirements of both the proper evidentiary arguments and the circuits in which those apply. Now, we're here in the Second Circuit, and fair is the law of the land, and fair, which has not been overruled or receded from in any way, makes it absolutely clear the plaintiff must submit that original promissory note in the context of that foreclosure trial when the defendant attorney makes a proper evidentiary objection. And that's the problem. We got pro se people walking into court making some arguments that don't carry the day. Now, even in those cases where plaintiffs do come into court with a copy, but the defendant doesn't make a proper objection, they may get away with it. And that's the problem with so many of these proceedings right now is that if the defendant isn't doing their job making proper objections, then quite frankly, the plaintiff is entitled to judgment. It's not the job of the court to do the defendant's job for them and make these technical arguments any more than it is the job of the court to fall over backwards and help the plaintiff to do their cases. That's a frequent criticism that we make. It's a valid criticism, but what's good for the goose is good for the gander. That applies both ways. Now, the argument that I like to use when a defendant stands up and says, Judge, objection, that's a copy of a plaintiff, of a promissory note. It's not an original note. And the plaintiff's attorney goes, Judge, just take our word for it. That original note has been filed. And the judge will look back and go, well, yes, counsel, you got an attorney here that's saying the original was filed. But you say, Judge, it's no different than if we were sitting here in a criminal trial and the prosecutor says, Judge, just take our word for it. That gun, that original murder weapon is in an evidence locker somewhere. Just take our word for it. No, we wouldn't do that in a criminal trial. If the defendant makes a proper objection that the plaintiff hasn't submitted the evidence of the murder weapon or whatever else they need, of course the judge is going to sustain that objection and require the prosecutor to fulfill their burden. Now, I question whether in a criminal trial, if the prosecutor didn't have all that evidence, whether the judge would grant them a continuance to go and get their evidence. I don't think they would. And the same standard should apply in a foreclosure trial. They need to be required to go back and get their evidence and not grant a judgment as a result of that. Now, I've got a couple potential appellate issues coming up and rehearing issues where at trial, the plaintiff made representations that an original note was on file when in fact, when we examined that alleged original note, it was not an original note. And in one particular case, and I may be doing an appeal, if the appellate or if the trial order finding foreclosure isn't vacated or found against that file order, then we will be appealing it. But in that particular case, the plaintiff filed a notice of filing original note in 2010 or something like that. And then when we get to trial, we revealed that what we had been saying all along for many years is in fact the case. That was not an original note. It's a photocopy. Now, even though we went to trial on this, plaintiff counsel persisted with this notion that the original note was in fact in the court file. Well, now I've hired two separate experts, document examiners, who look at these documents and go, we don't need to be an expert to make it clear that that's not an original promissory note, and yet that's what we're required to go forward trial. And we've got a rehearing coming up, and if they don't recede from that position, we're going to file a motion to vacate, then maybe a wrongful foreclosure action. But the point of the matter is this. Original notes are required in foreclosure proceedings if the defendant makes the proper objection at trial.